There are two types of assumption of risk. We have looked at express assumption of risk already, and now we turn to implied assumption of risk. And we'll try to figure out the several different types of implied assumption of risk that you can have. First, we have an old case by Judge Benjamin Cardozo, someone that we've seen in previous cases such as Paul's graph. I have searched and tried to find some old photos or video of the flopper ride that's at issue in this case, and while I found some images of the amusement park itself, I haven't located images of the flopper. The plaintiff here was apparently injured fairly badly. He had a broken kneecap, and it kept him from working for approximately a year. The jury ruled in favor of the plaintiff here and awarded him $5,000. But Cardozo rules in favor of the defendant, so the plaintiff loses and won't recover any money. Why shouldn't the plaintiff be able to recover for this injury? Cardozo basically says that when you participate in something like this and you know it's dangerous, you assume the risks. And that's why they call it implied assumption of risk, because it's not a situation where you're expressly assuming the risk and actually saying, I won't sue you, I won't hold you liable for this. But in some sense, you're implicitly assuming the risk because you know it's dangerous and you do it anyway. In the note after the case, I asked a question. What exactly is Cardozo saying? Is he saying that the amusement park was not negligent and what they did was reasonable and fine, so there's just no negligence? Or is he saying that the amusement park was negligent, but this guy nevertheless can't win because he knew what he was getting into? I don't think there's a really clear answer to this, and that's why I put the question in there. It's trying to make the point that this idea of implied assumption of risk could have different effects. You could argue that it should mean the defendant isn't really negligent. They had a risk in the activity they offered, but it wasn't really negligent to have that risk involved in it. Or maybe it is negligent, but the defendant still shouldn't be able to recover because it's sort of this guy's own fault for doing something known to be dangerous. And I think Cardozo actually seems to be saying both of these things, and it's a little odd because they seem somewhat inconsistent. He seems to be saying both that there was no negligence because the ride was safe and operated in a reasonably careful manner, but at the same time, he's saying that Murphy can't recover because he assumed the risk of injury because the dangers of this ride were so clear and obvious. And notice at the end that Cardozo reverses the lower courts, but then says he's granting a new trial. Why would they have a new trial? It seems like Cardozo has said the plaintiff just can't win, so why is he then saying there's a new trial granted? Nobody knows. In a moment, we'll see these different possibilities reflected in the different types of implied assumption of risk. But before we get to that, this Murphy case about the flopper is another case that has an interesting history and context surrounding it. Someone wrote a law review article about that aspect of it, and I thought it was very interesting. They looked back at the cultural significance of Coney Island in that era, the 1920s, and what amusement parks like this were all about. Before the amusement parks came along, Coney Island was a place that had a bad reputation. It had a lot of prostitution, con artists, gamblers, and various sorts of petty criminals. Eventually, the area got cleaned up to some extent, and in the 1890s, they started opening amusement parks there. And they were wildly successful. They had more annual visitors than Disney World and Disneyland do in modern times. In these days, we might tend to think about these sorts of amusement parks in terms of their appeal to children. But this article explained how back in those days, there was still a lot of sexuality wrapped up in these places. The basic idea was that society was significantly more sexually conservative or repressed in those days. Like if a man asked a woman to go out on a date, there was no reason to think there'd be any physical contact between them. Now, I'm sure that human nature being what it is, there was more going on than the social norms would suggest, but at the least the social expectation was that things would remain very chaste and innocent. And the idea was that these amusement parks were basically set up to give people an excuse to touch each other. Like right at the entrance to this steeplechase amusement park, you had to enter through something called the Barrel of Love, which was a giant rotating cylinder of polished wood, which was intended to throw people off balance and into each other's arms. A lot of the rides were designed to encourage closeness. This park was called Steeplechase because its main attraction was a ride where it's as if you're on horses, and a man could ride with his date and need to put his arms around her. The posters for the roller coasters would say things like, "She'll be so scared she'll throw her arms around you."
She's my Coney Island baby. She's my Coney Island girl.
And some of the attractions or shows there were also designed to have the additional effect of causing women's skirts to be lifted, exposing their legs or even their undergarments. For example, they would have holes in the floor with air hoses underneath to emit blasts of air that would lift ladies' skirts.
It played for almost 70 years, New York's longest running show. As a couple stepped onto the stage, a jet of air blew the woman's skirt up around her waist, while the dwarf gleefully shocked her date with an electric cattle prod. The audience shrieked with laughter and waited for the next victims, while the latest ones took their seats in the crowd. Sometimes the manager had to darken the stage and empty the theater so a new audience could push in.
And the writer argued that all of this context influences the way Judge Cardozo looks at this. Benjamin Cardozo was not the sort of guy who was comfortable with the boisterous, sexually charged atmosphere of a place like this amusement park. He was a very studious, serious person. One of his college friends described him as desperately serious. He apparently never did anything adventurous. He never traveled anywhere. His idea of a wild time was reading Greek and Latin texts. His favorite outdoor activity was taking quiet walks. And he had, by all accounts, a very repressive, Victorian sort of attitude towards sexuality. In fact, the general consensus is that Cardozo was celibate his entire life. He was never married, he lived with his sister throughout his life, and there's just no indication anywhere that he had any sort of romantic or physical relationships of any sort. He was actually a good friend of Judge Learned Hand, who we've seen from some other cases. And Learned Hand said that Cardozo was the least sexual person he'd ever met in his life. Cardozo just had no interest in that sort of thing whatsoever. So the robust, open sexuality of the carnival atmosphere at these amusement parks was alien and threatening to Cardozo. And this made him naturally inclined to think of Coney Island as a very dangerous, threatening place, where if you get hurt, you really knew what you were getting into, and you had it coming to you. And reading the opinion like a piece of literature, somewhat like we saw with Paul's graph, you can find ways in which Cardozo's tone and word choice convey this feeling of disorder and the unrestrained crudity and coarseness of the mob of ill-bred people, like the plaintiff, who would be drawn to this sort of place. For example, in the second sentence, he calls the flopper one of the supposed attractions of the amusement park, being sort of haughty, like, well, I wouldn't be attracted to this, but I suppose some people consider it an attraction. And he refers to the antics of the clown, and to the ride as being like a rough and boisterous joke, and the guffaws evoked by the horseplay of the crowd. Apparently the term horseplay, or to horse around, was a euphemism for sexual intercourse back in the 1920s. It's all very condescending, like he's looking down on the sort of low-class people who would be into this sort of thing. And in any event, he's completely unsympathetic to some guy, like the plaintiff Murphy, who chooses to frolic with women on something called the flopper. I mean, for goodness sakes, the flopper. Just the name itself sounds like some sort of sexual euphemism. So that's a classic old case about the concept of assumption of risk, but it isn't super clear at all about laying out exactly what the rules are for this. But the other case you read for today does exactly that. It's the Coomer versus Kansas City Royals case about the Royals mascot Slugger throwing a hot dog and hitting the plaintiff and injuring his eye. This decision was in 2014, and the Supreme Court of Missouri lays out exactly how all this works under Missouri law. And I think it's consistent with what is on the chart that I provided to you about assumption of risk. So let's take a look at this and go through this sort of map of assumption of risk. You need to ask yourself a series of questions. First was their express assumption of risk. Again, that would require that the plaintiff agreed to waive liability. The agreement could be written or spoken, or even manifested by the plaintiff's behavior rather than by words. But one way or another, you would need an agreement to waive liability. Again, the tricky thing is that express assumption of risk doesn't necessarily have to be express. It can be an unspoken agreement as long as there really is an agreement. If you have express assumption of risk, then the plaintiff loses, and there's no liability. If you don't have express assumption of risk, the defendant might try to argue that there was implied assumption of risk. Implied assumption of risk means the plaintiff voluntarily chose to encounter a known danger. So, those are the key words, voluntary and known. If you don't have express or implied assumption of risk, then you're done. There's neither type, and so there's no assumption of risk. But if there is the implied assumption of risk, that leads to several more questions. First, you must draw a distinction between primary implied assumption of risk and secondary implied assumption of risk. Again, both of them involve situations where a plaintiff voluntarily chose to encounter a known risk. But primary implied assumption of risk is where the plaintiff was injured simply because the activity in question has some inherent or inevitable danger. It's just an inevitable part of the thing. It's just part of the nature of it. It's just the way it is. And because the danger is an inherent part of the activity, we don't expect the defendant to eliminate that danger. Indeed, if the defendant exercises reasonable care, that danger will still be there. The defendant's use of reasonable care won't eliminate it. So, for example, suppose that someone goes on a roller coaster ride at an amusement park and then complains that it was a little scary. Well, a roller coaster is supposed to be scary. That's the whole point of it. Being scared is an inherent part of the activity, so you don't expect the maker or operator of the roller coaster to eliminate the scariness of it. Or if you decide to participate in some grueling event, like an ultramarathon running race, or the Tour de France bicycling race, or the Iditarod dog sled race, and then at the end you complain that, I'm very tired, that was really exhausting. Well, that's the inherent nature of the activity. We don't expect the organizers of these kinds of events to eliminate the parts of the things that make them inherently so grueling. Or if you want to do some kind of fighting sport, like wrestling or boxing or karate or other martial arts, getting hit is an inherent part of those activities, and sometimes it's going to be painful. And yet we aren't going to try to eliminate that pain. We're not going to try to force anybody to try to run a mixed martial arts competition that is pain-free. That's the basic idea of primary implied assumption of risk. You can't complain about something that is an inherent part of the activity that we want to preserve. Or another way of putting it is that in these situations, the defendant has no duty to eliminate the risk in question. No duty. It might be possible to eliminate the danger, but even if it is possible, we're not going to demand it, because it would basically ruin the whole point of the thing. It would take away something that we consider to be an inherent and acceptable part of the activity. We don't want to take the fear out of roller coasters or the pain out of boxing. And that's essentially what it means to have primary implied assumption of risk. It means the plaintiff is complaining about something that is an inherent risk of the activity that the defendant has no duty to eliminate. And the result is that there's no liability. Zero, none. Indeed, we probably could simplify things by just getting rid of the doctrine of primary implied assumption of risk and folding it into the duty analysis, so that whenever we treat a claim as being barred by primary implied assumption of risk, we could instead just reach the same result by saying there's no duty to eliminate that particular risk. I think that would clarify and simplify the law, and I think that's more or less what the Supreme Court of Missouri does in Coomer. They say that implied primary assumption of risk is really an issue of duty. Treating this as part of the duty element rather than as some kind of separate concept or affirmative defense does make a difference, because duty is a legal issue for the judge. I think that prior to Coomer, the prevailing notion was that assumption of risk, including the primary implied type, was to be treated as a factual issue, with the burden of proof on the defendant as a defense. And Coomer clarifies that it's really part of the duty analysis, and therefore it's a legal issue for the court to decide. It's not a factual question to be decided on a case-by-case basis. Notice that there's a footnote saying how it's an objective question, not a subjective question about whether this particular guy actually knew about the danger. It's a broader, general, objective question about what risks are known by people in general. And I don't think they spell this out explicitly, but it sounds to me like this means the burden of proof is on the plaintiff, because it's part of the elements of the tort. It's part of the duty element. So it's not really an affirmative defense where the burden would be on the defendant. If you have implied assumption of risk, and it's not the primary kind, then it's the secondary kind. So secondary implied assumption of risk is for dangers that are not really an inherent part of the activity. And in the old days, like more than 40 or 50 years ago, secondary implied assumption of risk was treated as being a total defense. It meant there was no liability. The plaintiff voluntarily chose to encounter a known risk, and that automatically barred the plaintiff from recovering anything. But times have changed. There's been some evolution in how we handle this sort of thing. In particular, there's been a major shift in dealing with plaintiff's conduct, with 46 states getting rid of contributory negligence and adopting some sort of comparative fault rule. So we now try to look very carefully at exactly what the plaintiff did and what effect it should have. We try to be very calibrated or proportional about it. And the same is true today for secondary implied assumption of risk. It's no longer a death sentence, no longer a total bar for the plaintiff's claims. Instead, when there is secondary implied assumption of risk, it comes down to a question of whether the plaintiff's action was reasonable or not. The plaintiff chose to voluntarily encounter a known risk. Was that an unreasonable, bad decision, or was it a perfectly reasonable, understandable thing to do? If it was unreasonable to voluntarily encounter this known risk, that's essentially the same as saying the plaintiff's own negligence was part of the cause of the injury. And so it's just handled as part of the comparative fault calculation. If the plaintiff made an unreasonable decision to do something while knowing it was dangerous, then there's some comparative fault. So unreasonable secondary implied assumption of risk really winds up being just a particular species or type of comparative fault. And on the other hand, if the plaintiff acted reasonably in voluntarily encountering a known risk, then that's no problem. We won't blame the plaintiff for doing something that was reasonable. So the plaintiff can recover in full. So in most states, secondary implied assumption of risk winds up just being folded or merged into the comparative fault rules. It's subsumed within comparative fault. It's just a species or type of comparative fault that might reduce the plaintiff's recovery by some percentage. And that means it is an affirmative defense. The burden is on the defendant. And it's a factual question for the jury. And as it says in the footnote, it's a subjective matter of what the defendant actually knew and understood, because it's about whether he voluntarily encountered a known danger. If there was a danger that the defendant did not actually recognize, but reasonably should have, it seems like that could be comparative fault as well, but it just wouldn't be the assumption of risk variety. I think that one of the hardest issues for implied assumption of risk is when we say that you voluntarily encountered a known risk, how specific does your knowledge of the danger need to be? There was a case I saw once about a maid who tripped over some things that children had left on the stairs in the home. And she sued the family, and they said she voluntarily encountered a known danger. Well, was that true? It depends on how you look at it. The maid apparently knew that in general the kids sometimes left things on the stairs. But she apparently didn't know about the items on the stairs on the particular day in question. She didn't see them because she was carrying a bundle of laundry. So she knew about the danger in a general way, but not in a really specific way. And is that enough to have secondary implied assumption of risk? And I don't think there's a clear-cut, easy way to answer that question. The answer is it's somewhere in between those. You need more than just a very general awareness of the risk, but less than a highly specific, exact awareness of it. And I think you could figure that out just from your common sense. For example, suppose that somebody purchases a new tire and there's something wrong with it, so the tire blows out and the person has a crash and gets hurt. And let's say we're trying to decide whether there was implied assumption of risk. Did the plaintiff voluntarily encounter a known risk? Well, we don't want to make it too easy to have implied assumption of risk. Like if we said, well, the plaintiff drove the car despite knowing that it is possible for a tire to fail. Yeah, it is true that everybody knows in a general way that sometimes tires do have blowouts. Everybody is aware in some general sense of that risk. But if that was enough to have implied assumption of risk, then there'd always be implied assumption of risk. Every time you get into your car, you know there's some possibility that the car could break down. So that very general awareness of the risk shouldn't be enough to constitute implied assumption of risk. And on the other hand, we don't want to go too far in the other direction either. For example, suppose the plaintiff knew that there was something wrong with that particular tire, and knew that it was very likely to have a blowout pretty soon, and therefore knew that it was awfully dangerous to be driving on that tire. That should count as implied assumption of risk, right? And the plaintiff might say, well, I didn't know exactly when or where it was going to blow out. I didn't know it was going to happen at that specific time and place, so therefore I didn't really know what was going to happen. But that would be wrong. If we required the plaintiff's knowledge to be that specific and precise, then we'd almost never have implied assumption of risk. So you'd want to draw the line somewhere in the middle. It would probably be enough that you knew there was a problem with a particular tire, but you chose to keep driving it on it anyway. In other words, the required level of knowledge must be somewhere in between the very general awareness that we all have about the dangers in life and the completely specific knowledge about exactly what is going to happen, which we rarely have. In the case about the housekeeper who fell on the stairs, you could argue that she didn't voluntarily encounter a known risk unless she actually knew there were items on the stairs that day when deciding to go down the stairs. But I think that would be requiring too much. That would be making the known risk requirement too difficult to satisfy. And on the other hand, you could argue that everybody in the world knows about the risk that there could be something on a staircase. So you could say that we all voluntarily encounter that known risk every time we go down any stairs. And I think that would be requiring too little. That would be making the known risk requirement too easy to satisfy. So to recap, if we have express assumption of risk, that can be a total bar to any liability, to any recovery. If we have the primary implied assumption of risk, it means that there was no duty, and that's also a total bar to liability. And if we have secondary implied assumption of risk, that's part of comparative fault, so it might reduce the damages, but it's not a total bar. Here, in the Coomer case, we can go through the analysis. You could ask whether there was express assumption of risk here. Although the Royals tickets do have a disclaimer of liability on the back, we know that's probably not really enforceable unless the plaintiff wants to admit he read it and agreed to it. For implied primary assumption of risk, the question would be whether this risk is inherent in a baseball game. Would we say the defendant has a duty to eliminate this risk, or is there no duty because it's just an inherent part of the activity? The court decides that this is not an inherent part of a baseball game. It's not inherent that you have to throw hot dogs toward the fans. Notice that they suggest you could have some dangers at a baseball game that are inherent parts of the sport, like getting hit with a foul ball or a piece of a broken bat. That's the baseball rule that they talk about. And on the other hand, if you got hit by a ball while you were in the interior walkways of the stadium rather than in the stands, then maybe that's not an inherent risk. So here they decide this is not primary implied assumption of risk. It still could be the secondary kind, and that is a factual issue for the jury. It basically boils down to whether a jury will think that this plaintiff was negligent and he voluntarily encountered a known danger in an unreasonable way, such as by not paying attention when the mascot started to throw the hot dog. This case was remanded for a new trial with proper jury instructions, so that the jury would consider secondary implied assumption of risk only, and it would be part of the comparative fault calculation. And after that second trial, which was in the summer of 2015, the jury ruled that the Royals were not negligent, and the plaintiff was not negligent either. So it was no one's fault. It was just an accident, and so the plaintiff did not recover anything.
Over to John.
How disappointed are you today?
Well, disappointed, especially considering the fact that, based on testimony, the Royals knew mine was not an isolated circumstance.
Mm-hmm.
It was not. There were past, issues of Mr. Shore's slugger as far as the way he was throwing hot dogs that his management was talking to him about. So this wasn't a surprise. It wasn't isolated. I think the argument in court was my level of responsibility of paying attention. We've got a beautiful new stadium with a lot of things to look at. We were looking at the scoreboard and the ribbon boards. I understand that. I understand what happens in a game during the course of action with bats and balls. This has nothing to do with that. And for something like a hot dog toss, I'm not saying it needs to go away. I just think it, but it could just be done responsibly. Hey, I'm a big guy. I played sports, but when things come at you that you don't expect or don't anticipate or didn't ask for, I think it's a little unfair for me to have to react to that. So that's all. But I just hope people are just a little more responsible going forward. That's all.
To wrap it up, take a look back at the complicated chart of assumption of risk, and notice that we could make this a lot simpler and clear up some confusion by only talking about one type of assumption of risk. We could stop talking about primary implied assumption of risk and just treat that as part of the duty or no duty analysis. And we could stop talking about secondary implied assumption of risk because that's just part of the comparative fault analysis. And the only thing left would be express assumption of risk, where there was an agreement to waive liability. And we might stop calling that express assumption of risk and use another term like assumption of risk by agreement. The courts are moving more and more towards that, and the restatement is as well, as you see in the notes after the case. I think the Coomer decision does a really good job of clearing up this area for Missouri law. And while it continues the use of the assumption of risk terminology, and the primary kind and the secondary kind and all of that, it does a good job of explaining why the primary type is really just part of the duty issue, and the secondary type is really just part of comparative fault. So in the future, one would think maybe things drift toward just forgetting about calling these things assumption of risk and just abandon that terminology. But sometimes these sorts of terms do linger, even when they aren't really needed, just because people are so familiar with them. So it wouldn't surprise me if lawyers and judges keep talking about assumption of risk for a long time.